But having said that, we must strengthen our institutions of democracy that would exact accountability rather than keep on adding bodies. That is why I am in favor of this, in favor of the proposed commission, but it must be an ad hoc, it must have a sunset clause rather than perpetually having a duplication of functions.
I understand, Senate President Drilon, you were suggesting, considering that this is only 3 pages, that you'd like to go through. Go ahead.
Yes, in order to maximize our time, Mr. Chairman, if I may, first, after listening to our the resource persons, first we must emphasize that this is a fact-finding body that we are trying to form. The power is to investigate, not to adjudicate. It cannot conduct preliminary investigation, which is the role of the prosecution service, and it cannot much less adjudicate, which is a judicial function. So it is limited correctly to only investigation. Having said that, under our system and our constitution, the primary jurisdiction for investigation of anomalies is the Ombudsman. The Ombudsman is the primary body, but that does not prevent us from creating this commission. But having said that, we must strengthen our institutions of democracy that would exact accountability rather than keep on adding bodies. That is why I am in favor of this, in favor of the proposed commission, but it must be an ad hoc, it must have a sunset clause rather than perpetually having a duplication of functions. We recognize the Constitution. The Ombudsman has the primary authority. We strengthen the Ombudsman. For example, I read in the media that the Ombudsman has asked those who applied earlier to apply again, about 200 or so vacancies. So we must strengthen this because otherwise, the tendency, and I have been in this body before, the tendency of our structure is to keep on adding people so that you create a huge bureaucracy. Every problem that crops up, we solve it by creating an office. In this particular case, I am endorsing the commission creation because of the situation that we are in. But we should not forget the fact that our primary objective should be to strengthen our institutions of democracy that could demand accountability, and in this particular case, the Ombudsman. But we have to have this ICI, or however we will call it, because of the need of the times. But as I said, we must remember that this should be limited to fact-finding. In fact, that's recognized in the bill of the Senate President. It's only fact-finding and only limited to infrastructure projects. In other words, if another Farmally case would come around, it is not in the purview of this body, because as the Senate President himself said in his measure, it is limited to infrastructure projects, past and present, but limited to investigation. In other words, it is a fact-finding body, and it will now recommend to the Ombudsman or to the prosecutor the prosecution of cases. But commenting on certain areas,
On the issue of the sunset provision, what timeline are you looking at?
Just off the top of my head, subject to further discussion, the term of the present administration, June 30,
2028.
2028. But it's just something that we make as a reference. As I have no problems with my issue is it must have a sunset provision so that we will not have duplications. But to address the need for inadequacies in the system, we should strengthen the Ombudsman. We strengthen the COA by adequate funding. That's my submission, Mr. Chairman. Rather than creating a permanent body which will again investigate or do work or do the functions of the Ombudsman. That's my submission.
Yes, Chief Justice Puno, go ahead.
Are you done?
But there are others, but I can.
You may interject, Chief Justice Puno, in relation to the points earlier said.
No, I would like to former Senate President Drilon to continue. And then I'll also have my time
Okay.
to comment on
Okay,
the
yes.
specific provisions of the Senate bill.
Yes.
So, okay, just on the, going back, on the remedies on the powers which the one of our resource person mentioned, the issuance of an HDO, I would not agree that we place this in the hands of an administrative body. It must be a judicial determination because it involves the rights of individuals to travel, the right to abode. If you an HDO is a very powerful power of government, and to allow, it must be a judicial finding. Other administrative remedies, we would endorse depending on
Perhaps the minimum would be a lookout order.
lookout order. Yeah. Now, the controversial issue, Mr. Chairman, is the power to hold a person being investigated in contempt. We should be very careful here because of the right against self-incrimination. Remember that the persons being called to the hearing of the ICI face potential criminal liabilities. If the ICI or the body is empowered to recommend the prosecution of people, and having said that, if one invokes his right against self-incrimination, we cannot order the detention of that person until he cooperates. The example in the Senate or in the House cannot be cited because the objective of an investigation in the Senate and the House is in aid of legislation. Now, on the other hand, the ICI or this independent commission can recommend the prosecution, and therefore we cannot. I have very serious reservations about granting them the power of contempt. We have on. I think we should.
On that point, Senate President Drilon, what you're saying is the remedy perhaps of this body, of this proposed body, would be to go to court
Yes.
and seek the contempt order from the court.
Yes. Yes, sir.
And maybe the Court of Appeal, so that it's
Whatever, but it cannot be no, and the principle, whether it's in the regular court or in the or this body, where the contempt would require the answering of questions which can incriminate, whether it's in this body or in the court of law. In my mind, the right against self-incrimination.
For example, well, we do have this case with the Discayas.
Yes.
They now refuse to cooperate with the ICI.
Yes.
Well, what is the remedy of the ICI? Or what should be
The remedy of the
remedy?
ICI,
Yeah.
the remedy of the ICI is to assess what they have gathered as evidence, recommend to the Ombudsman whatever action they find necessary, and the lookout of the Discayas is that the matter will be decided without their evidence that is presented. But that is how the system works, because another system could have more dangers. Now, the matter of it is also mentioned by the private, by the businessman that some private group must approve the appointment of the president. I don't think that's possible because the power of the president to appoint is constitutional. He is the appointing authority. He is elected by the people. For a private group to be given the power to pass upon these appointments, regardless of how well-meaning they are, I don't think that can stand constitutional scrutiny, Mr. Chair. So
They can recommend.
they can limit. For example, there is nothing wrong with recommendation, and we can even legislate as proposed by Senator Soto that the nominations of, say, of a retired justice must be passed upon by. It can be exercised by some group, integrated bar, can recommend. The president's power to appoint can be limited by that. His authority can be exercised only on the nominees. Now we have done that, Mr. President, in existing laws. I myself wrote that in the charter of the Professional Regulatory Commission, so that only those recommended by the professional body can be appointed as a member of the boards. Pwede po yan. So, I mean, we have done that.
Then in my case, the Coconut Levy Trust Fund
Yes, the Coconut Levy Trust Fund.
Measure and the
representative of the farmers
Yes.
must be nominated by
That's
the
right.
farmers group.